the Department has informed that no record of having received any claims against the decent group to date. That is the situation. So that obviously your comment is, I have no doubt the Minister directly will respond to you directly on this issue as well. That will be, so beyond that is what that's the current situation as we speak at the moment.
Thank you, Minister. Final motion adjournment is from Senator Jillian van Turnhout. And Minister, you taking this one as well?
Correct.
Okay. All right, glad, Senator.
Thank you. Welcome, Minister Perry, to the House. The Reception and Integration Agency of the Department of Justice and Equality is responsible for the accommodation of asylum seekers in accordance with the government policy of direct provision. And according to RIA's latest monthly report, that's of June 2012, there were 4,900 people on RIA's live system, i.e. that 4,900 people are living in direct provision accommodation centres throughout Ireland. 1,723 of this number were children. Of this number, 907 were children aged between 17 and 5, and 816 were 4 years and younger. And I know that Minister Shatter is very aware of the Irish Refugees Council report entitled State-Sanctioned Child Poverty and Exclusion, the Case of Children in Accommodation for Asylum Seekers, which was published on the 18th of September last. And this report paints a bleak and indeed a very worrying picture about the treatment and care of children in direct provision. It documents frequent instances of poverty, malnutrition and dietary-related illnesses among young children in Ireland. The findings of the IRC report are very much in keeping with the concerns raised by the Government's Special Rapporteur on Child Protection, Dr. Geoffrey Shannon, in his 2011 report, in which he highlighted the specific vulnerability of children accommodated in the direct provision and the potential or actual harm which is being created by the particular circumstances of their residence, including the inability of parents to properly care for and protect their children. Dr. Shannon has also expressed concern about the real risk of child abuse in direct provision accommodation, where single-parent families are required to share with strangers and where families with teenage children of opposite gender are required to share one room. He cited the case of a 14-year-old girl in a centre in Mayo became pregnant by a male resident in the same centre in September 2011 in support of his concern. Given the parallels between Dr. Shannon and the IRC's respective reports, I was surprised by the tenor of the response on behalf of Minister Shatter to my colleague Senator O'Flaherty's recent adjournment motion that the IRC findings and conditions simply seemed unlikely. And I really would like to say this strongly. That said, I do welcome that the Minister has directed that the report be comprehensively examined and any issues arising be addressed. I welcome in particular his directing that issues relating to child welfare be dealt without delay. I'd be interested to hear from the Minister about the logistics for his comprehensive examination, who will carry it out and when we can expect a report. What we cannot lose sight of when we're talking about children in direct provision accommodation is the very fundamental premise that a child is a child, irrespective of country of origin and regardless of the application status of the parent or parents. The welfare and protection of children must be always at the forefront of what we do. It's timely to be debating this adjournment motion on the very same evening as we pass the second stage of the 31st Amendment of the Constitution Children Bill 2012 earlier today. In recent years, the Oireachtas has spent significant time discussing horrific reports about the institutional abuse of children. And I suppose to get to the point of my question, what I'm genuinely concerned about here is our treatment of children in direct provision will be our shameful report in the future. And I, like many others, am doing my best to ensure that this does not happen. So my questions are, and I'm going to limit them in this juncture to these questions. Can the Minister confirm the number of children living in direct provision that have been born in Ireland or born to an Irish parent? Are the HIQA National Standards for the Protection and Welfare of Children for Health Service Executive Children and Family Services, published in July 2012, applicable to children in direct provision? I understand that RIA's Child and Family Services Unit is responsible for the monitoring and implementation of RIA's child protection policy and does so in close partnership with the HSE Child Protection and Welfare Service nationally. I note in particular in the standards which stipulates that child protection and welfare services provided on behalf of statutory service providers are monitored for compliance with legislation, regulations, national child protection, welfare policies and standards. Features to meet the requirements of the standards include under 341, formalised agreements are in place for the provision of child protection and welfare services for children and families which are sourced externally. 342, formalised agreements including the scope of service provided, resources required to deliver the service, monitoring governance arrangements, including the compliance with national policy, children first and relevant standards. And finally, 3.43, which says external service providers are monitored on a regular basis to ensure the service provided to children and families is compliant with legislation, regulations, these standards and national policy. So, in my opinion, the national standards for protection and welfare of children clearly apply to direct provision. However, in preparing for this evening, nobody can assert this for me. And HIQA I've contacted RIA, I've tried. I'd like to know what arrangements are in place for the inspection of direct provision accommodation centres in accordance with these standards. Thank you.
Thank you, Senator Van Turnhout, for this very important issue. And I responded to this subject today on behalf of my colleague, the Minister for Justice, Mr. Alan Chatterjee. The Reception and Integration Agency, RIA, of the Department of Justice and Equality, is responsible for the accommodation of asylum seekers in accordance with the Government's policy of direct provision and dispersal. Standard 3.4 of the HIQA National Standards states as follows: that child protection and welfare services provided on behalf of statutory service providers are monitored for compliance with legislation, regulations, national child protection and welfare policy and standards. These HIQA standards apply to the HSE children and family services or any subsequent agency that takes on the HSE statutory function under Section 3 of the Child Care Act 1991. These functions include protecting and promoting the welfare of children at risk in the community and supporting and protecting children in the care of the state. Children living in the direct provision system care or not in the care of the state all live in a family context, and their parents, guardians have primary responsibility for their care and welfare. Neither does the RIA accommodate unaccompanied minors that are in the care of the HSE. While HIQA standards do not apply directly to RIA, they apply to the HSE children and family services in the context of its role in dealing with any children living in direct provision who refer to it. Such referrals can be made under RIA child protection policy, but may also be made by, for example, GP, teachers, etc. Responsibility for child and family services is assigned to a specific unit in the RIA called the Child and Family Services Unit, whose role is to manage, deliver, coordinate, monitor and plan all matters relating to child and family services for all asylum seekers residing in the direct provision system, and to act as a conduit between the RIA and the HSE and, where necessary, the Gardaí. The RIA and the HSE cooperate closely in respect of the needs of residents, particularly children, in all centres. Discussions take place through interagency meetings, health liaison officer meetings and medical screening services meetings, working groups on matters such as healthy infant feeding guidelines, child protection, psychology and other health service groups. The RIA has a child protection policy based on the HSE Child First national guidelines for the protection and welfare of children, and this policy is currently being updated in line with the recently revised HSE Children First policy published in July 2011. All staff working in the RIA centres are Garda vetted and trained in the RIA child protection policy. The RIA takes its role regarding the welfare of children and vulnerable adults very seriously. It is satisfied that its child protection policies comply with all national standards and policies. It is a difficult and complex matter to definitively establish, particularly in the short time involved, the number of Irish children living in direct provisions in the system. In a recent report by the NGO, it was described as a considerable number, but there is no evidence whatsoever that this is so. In fact, the likelihood is that the cohort involved is extremely small, and currently the number of people being accommodated in direct provision system is just under 5,036 centres throughout the state. The principal difficulty is that it is common for asylum seeker families to have a child born while residing in the direct provision. In some cases, these parents may have a mistaken belief that their child is an Irish citizen by the dint of being born here. However, this is clearly not so, as since the 1st of January 2005 there is no automatic right to Irish citizenship. Some parents in these circumstances do not make an asylum application on behalf of the child, and the exact nationality of the child only becomes definitively known when such an application is made, sometimes arising, for example, a deportation order issuing against the rest of the family or the institution of legal proceedings. From a practical point of view, the RIA must continue to accommodate that child with his or her family, notwithstanding the uncertainty over the child's nationality or asylum status. The Minister has asked his immigration officials to examine this statistical issue in more detail and communicate directly with Senator van Turnhout further on this matter.
Thank you.
Just very briefly, just to clearly state again, and I will be pursuing this issue, I do believe these standards should apply to these centres. They are a statutory agency of the state. I don't agree with the interpretation that is being put forward, but obviously I will pursue that further with the Minister. Equally, when the Minister is looking for the numbers from me of children, to note, yes, I do very much note the date of January 2005, but potentially you could have children who are 7+ indirect provision who are Irish citizen children, but because of the status of their parents, they may be in direct provision. I really do believe, and I would encourage colleagues to visit these direct provision centres, because we talked about the Ryan report in the past, that there was society kind of knew this was happening.
Yes.
It is happening in the direct provision centres. It will be a shocking and damning report in 20 years' time if we don't do something now. And I do believe that Minister Shatter is a very strong defender of children's rights and child protection, and that's why I'm raising the issue.
Right, thank you very much. Thank you, Senator van Turnhout, and thank you, Minister. And the House stands adjourned till 10:30 Magna Mara.